Good morning, everybody. I'm just going to give it a couple of minutes because I can see everybody jumping into the session. So good morning as you're all joining. Good morning, all. Still more joining. It's good to see it's always interesting to see the numbers going up the screen. So good morning as you are joining. We'll just give it another couple of seconds for everybody to get in this morning. Okay, good morning, everybody. I'm going to introduce our panel this morning. So I'm Ruth Mullen, and I'm here for the employment contingent this morning. Sat beside me is Gemma Duxbury, who does all things commercial, governance, procurement, and information, all the interesting stuff. And we've also got with us today Sharose, who is from our litigation team. Catherine, who is our professional skills lawyer, does lots of training and all the legislation for us. Nicola, who is the partner in our insurance team, who works very closely with schools as well. And Sam Gorrell, who works for our housing and property team and does all things relating to education property. So good morning, panel. Good morning, everybody that's attending this morning. We've got quite a variety of questions this morning. As we go through the webinar, if you do have any questions that you haven't sent in advance, please do pop them onto the chat and we will try and get through to your questions accordingly. So we're going to start this morning with a discussion from Nicola about something that she's seen in relation to mesothelioma. So this is about, Nicola, good morning, that something has been seen on Good Morning Britain about a woman suffering from mesothelioma and a discussion about there being a central asbestos register. Could you tell us a bit more about that and what that would involve?
Absolutely, Ruth. Thank you for that. So, yeah, I'm a partner in the insurance team and I deal with claims for occupational diseases. So I've acted on behalf of lots of local authorities and schools as well as insurers and looking at those sorts of claims. Particularly, we see a lot of asbestos-related condition claims. And I don't know how much people know about them, but there can be a variety of horrible diseases. The particularly worst one is mesothelioma, which is quite an aggressive lung cancer. Which is caused by asbestos exposure, but it can take quite a while between exposure before you start to get the symptoms. So it can be anything between 10 and 40 years. So historically, when I started my career, we saw lots of claims from people who had actively worked with asbestos and were lagging pipes and heating engineers and things like that. But actually, over the last 10 or 15 years, what we're starting to see a lot more of is what's called secondary exposure to asbestos. So that is when people go into buildings and they're exposed to asbestos as a visitor or as an employee. So, for example, people that a lot of in schools, there's asbestos tiles in a lot of roofs. There's lagging on pipes in different places. And the important thing to note is that asbestos isn't harmful if it's not disturbed, but if it is in poor condition, then the fibres are released into the air and it's possible to breathe it in. Now, as there's been more claims and there's more awareness, there's been a lot of press around this recently. So the Sunday Times have been running a campaign about asbestos in public buildings. And I don't know if anybody saw, but a couple of Fridays ago on Good Morning Britain, there was a younger woman who was a young mother who's developed mesothelioma from being exposed, I think, in a school as a pupil. So what that article, and particularly the Good Morning Britain article, was saying was, should there be a central asbestos register? Because many of you working in schools and education establishments will have an asbestos risk assessment and you'll keep those. And what people are calling for is for there to be a central register of all those risk assessments so that people know if they're going into a building, if asbestos is present and what sort of condition it's in. Now, they're going to take it, I think, a step further as all that information is collected and potentially have a QR code as you walk into a building that you can scan and see if, oh, my lights have gone off in my room. So, oh gosh, that was exciting. So as technology's developed, obviously, what the hope is that as you go into, you couldn't write it, could you? It's just comedy gold all the time. But a QR code, if you're going into a library or a school or a hospital or anything like that, that you can scan and see if asbestos is there and what condition it's in. So if there's any areas to avoid, you can avoid. Obviously, with anything like this, it's going to be quite onerous at the beginning for everybody to get all their documentation together and put those assessments on. How it will help is obviously it gives greater transparency to people coming into the building and to employees about what's going on and the risks of asbestos. But it can also help with insurance and getting insurance, because there's quite a lot of asbestos exceptions, particularly in public liability insurance. And it may well lead insurers to have a look at that, because obviously if you get a mesothelioma claim from a visitor to your school, for example, and you haven't got insurance, the damages can be in the region of hundreds of thousands of pounds, so looking at a minimum of £200,000. So that coming out of a budget can be a lot of money to deal with. So that's where they're looking at it. It's very much in its infancy at the moment, and as anything, it will take a lot of organisation and bureaucracy to get around it. So it's not something that's going to come in the immediate future, but it's probably something to keep an eye on.
Thanks, Nick.
No,
Well, it's really useful to know some of these things, because we don't always see these things cropping up, and having dealt back in the day myself with people with mesothelioma, it's a pretty horrible thing to have to deal with, isn't it? So
yeah, it's awful. Yeah,
we can get out ahead of it. I think it is really good. Thank you so much. And we're going to move on now to something completely different, and Kat is going to talk this morning about some changes that are due to come in on neonatal leave. So over to you, Kat.
Yes, thanks, Ruth. So I just thought it would be useful to make you all aware of the new right for staff whose baby requires neonatal care. So obviously this is a horrible situation for any staff member to be in. And the government identified, I think it was the Conservative government actually, identified that there was a bit of a gap here in the protection for staff in this situation, where there is, a tiny baby in neonatal care, but actually once, especially for the partner of birth mum, once paternity leave is used up, they're then kind of a bit stuck as to if they're able to have time off. And what they were finding when the government conducted kind of a consultation on this and looked into it into more detail was that actually people were just taking sick leave, or were actually just leaving organisations because they just wanted to spend time with the baby. So as a result of that, the Neonatal Care Leave and Pay Act 2023 has been drafted and has actually gone through Parliament. And it now needs regulations to bring that into force. And the regulations, as far as we're aware, are going to come into force on the 6th of April of this year. So pretty soon. What that means is that from the 6th of April, provided that Parliament approves those regulations, is that there's going to be a new right for staff that have a baby that requires the neonatal care. And it means they're going to have a right to leave and pay. So it's quite a complex piece of legislation. There's different tiers of periods when people have time off as to what the notice requirements are and how this interacts with regards to multiple births, etc. So what I've done is I've written an article on it, which is going to be in our newsletter, which is going to be coming out shortly, which is very exciting for everybody. And it's also going to be on our social media platforms as well. So please do keep a lookout for that, because that's going to contain a lot of the detail of what's involved. But just by way of headlining, just so you're aware, so you can kind of get ahead of this. With regards to the neonatal care leave for staff members, they're going to be entitled to 1 week of neonatal care leave for each qualifying week their child spends in neonatal care. up to a maximum of 12 weeks. And it's going to have to be taken in weekly blocks. Now, there is a definition of what neonatal care looks like, but effectively, it's kind of what we envisage, where the child needs medical assistance when they're newborn, effectively. The neonatal care leave must begin. Sorry, the neonatal care must begin within 28 days of the child's birth and last for a continuous period of at least 7 days. So there is that criteria too. The employee in question is going to need a personal relationship with that child, so either a parent or a personal relationship. And this leave can be taken where the child has been adopted, including from overseas, as well as via parental order, so surrogacy arrangements. Now, what's interesting is this neonatal care leave can be taken in addition to other statutory leave. So the idea is that providing that the individual meets all the criteria, they can potentially take this leave on top of maternity leave. So this neonatal care leave is going to have to be taken within 68 weeks of a child's birth. So it can be taken on top of. There are specific notice requirements, which I've said, are quite complex. I'm not going to go through them all now because I will lose you. But like I said, we do specify this in the article. And an individual is going to have the right to return to the same job or in certain circumstances, a suitable and appropriate alternative job. So this leave is going to be a day one right, but there's also going to be an entitlement to pay as well. So again, if the individual's wanting to be paid for this time, for the statutory payment to be eligible, they're going to have this parental relationship or personal relationship with the child. It's the same definition for what neonatal care will look like. But for the pay, the employee is going to need at least 26 weeks continuous service ending with the relevant week. And the relevant week is the week immediately preceding the 14th week before the expected week of childbirth. And there are specific requirements for adoption and surrogacy too, with regards to entitlement. This individual is also going to have received normal work earnings for a period of 8 weeks ending with the relevant week, which are not less than the lower earnings limit. It's going to be paid at the same rate as statutory paternity pay, and it's going to be paid for a maximum of 12 weeks. And it's going to have to be taken within the 68 weeks from the child's birth. So that's kind of the headlines, I suppose. It's what to be aware of with regards to the 6th of April onwards. We are going to look at producing policies for this because it can be quite complex. So we will be saying look at updating your policies and procedures, and also make your staff members aware, especially those managers and HR, that this is going to be something that individuals are going to be entitled to pretty soon, provided that the parliamentary approval goes ahead as expected. So a quick canter through there, Ruth, but as I said, I would urge people to kind of look at the article that we've written in the newsletter, because that goes into more detail. And like I said, we'll be looking at policies as well.
Thanks, Kat. That's, again, really helpful. I think it's interesting to say that already we've started to see queries from mothers who are visiting midwives, and midwives are already telling them about this right. And unfortunately, in a couple of cases, of course, we've had to go back and say it's not actually enshrined in law yet until the 6th of April. So it is unfortunate for some of those people who are going through this at the moment that actually that leave provision isn't there yet. But it is coming, and as I say, it seems to be widely known about in the medical profession as well. So it is definitely something to be aware of and to look at your policies, as Kat said. One of the things that I wanted to do now was just kind of to open the floor to questions as well. We've got our chat box and we've also got our Q&A session. So if you do have any questions on anything that's been asked so far, or anything that you've thought of while you've been listening to us this morning, please do pop your questions on and we'll do our very best to answer them. We've got quite a lot of expertise in the room this morning, so please do feel free to pop your questions on and see if we can help. One of the things Gemma and I were dealing with just yesterday, in fact, was in relation to consent under GDPR. And when you write off for an occupational health report for one of your employees, how consent and then the disclosure of that occupational health report work together. And Gemma had to get involved for us yesterday on something where that consent process had been argued by the employee to have gone wrong, and the report shared with people that the employee didn't expect the report would be shared with. Now, one of the problems we have as employers is that you need to have that occupational health report disclosed to you so that you can actually put reasonable adjustments in place, or if a stress risk assessment needs to be undertaken, you can implement that. And within your schools, there will be a variety of people that have the knowledge and expertise to deal with that. So, for example, you might have one person who's trained to do the stress risk assessment, or you might need your head teacher to see that report to understand how reasonable adjustments are going to work. Or it may be that pay needs to be adjusted and you need to share something from that with somebody in the payroll team, for example, for legitimate reason, not just to share the document on. So I'm going to ask Gemma to just talk a little bit about consent and this issue that we've had.
You've sprung this one on me,
I sprung it on her this morning. But I just felt that it was quite an important thing that we've come across yesterday, because this went wrong and an employee was complaining about it. So Gemma, do you want to just talk a little bit about consent?
Yeah, of course. So obviously an occupational health report is considered what we call special category data, because it contains medical information and personal and private information. And what unfortunately had happened in these circumstances is that the employer had asked the consent of the employee, can we share this report with a particular member of staff? And it was for the report to be sent to that member of staff, which it was. And then it was actually shared with 2 other members of staff. Now, potentially, though, because obviously, it was shared with a member of staff, and it was some other third party, wasn't it, Ruth? So
yes.
The risk that we had here was that the employee said, well, hang on a minute, I've only given you consent to give it to that one person that I've sent it to. You didn't then tell me you're going to email it out to these other people. And the issue that we had here is that obviously under Article 6 and Article 9 of the UK GDPR, I sound like I know what I'm talking about now. Article 6 and Article 9 of the UK GDPR, you not only have to have a legal basis for sharing that, but you also need to be able, because it is special category data, to provide your reasons and your explanations in relation to that. And here you could legitimately argue that the people it was sent to were involved with that employee and they did need to know that information. However, because they had been specific enough to say, can we share it with that one person, by then doing that, they'd restricted to the sharing to that one person. So when you're getting consent for an occupational health report to be sent to anybody, it's much better to leave it on a wide range of things. So such as, for example, the senior leadership team, HR staff, those kinds of people, so that then if it is shared with them, now we can potentially argue obviously that there was a legal basis on the fact that it was in relation to the performance of the employment contract, and that also that it was in relation to the best interest for that member of staff, because we perhaps might need to consider reasonable adjustments at work, for example. But because they've been specific enough to just name that one person by sending it to anybody else after that point, then it's potentially a breach. So you've got to be really, really careful when you're thinking about these things, and try and keep it as broad as you possibly can. Because I can see both sides of it, because obviously there are some things that an employee might not want somebody to know, and that's fair enough because it is their private information. However, the employer, they need to know that information to be able to move things forward. So if you are going to ask somebody's consent to share anything, try not to be too specific or narrow it down to 1 or 2 people. You know, potentially, because you might need to share that with other members of the staff and the senior leadership team.
And also think about why you're sharing it. What's the purpose of sharing that information? You know, it might be, for example, you need a particular member of staff to conduct a stress risk assessment. That's one that we see quite often. But actually, do they need to see the whole medical report, or can they just be instructed by someone who's seen the medical report to say, actually, we need you to undertake a stress risk assessment without disclosing anything further? That may be more pragmatic than actually sharing the whole report. So just really think about
And
what it is you're doing.
It's common sense, isn't it?
Yeah.
That you would think that employee would know that certain members of staff would need to see that. But particularly if it's in a difficult situation, a contentious situation, then you're just giving them a reason to be able to complain if you narrow it down too much.
Brilliant. So we have had a question, and Kat, it's for you, on neonatal care. So in respect of neonatal care and the 2 tiers, the author says, I am interpreting tier 1 as being for those in emergency circumstances, whereas tier 2 is for those with a more planned situation. Is that correct?
So yeah, tier 1 covers the initial period of neonatal care. So from the beginning of care until 7 days after the newborn stops receiving it. And then tier 2 like commences after the tier 1 period ends. So yes, I would interpret it as that. It isn't very clear in the drafting as to kind of how this is going to work in practice. But yeah, tier 1 is certainly the initial period. Tier 2 is going to be kind of, where there may need to be some more planned leave, and that's where the notice provisions come in. But yes, that's my interpretation too.
Thanks, Kat, that's really helpful. I'm going to jump out of slight order of these questions now. I'll come to Sam. We've got something here about, given the widespread concerns about how schools are expected to cover the increasing cost of maintaining and upgrading their estates and properties, what does the latest education spending report from IFS reveal about the latest and future rounds of capital spending on school buildings and maintenance? Sam, that's going to be really important to some of our attendees about their budgets, and I'm sure we're coming up to budget planning at the moment. So let us know, what is it they can do?
Well, it's not good news, I don't think, but I'll talk you through now what the IFS report said in relation to capital spending in particular. The report itself was published on the 8th of January this year, and it covers education spending in England largely for the period 24 to 25. As I've alluded to, in part, it covers a whole range of spending, but in part, it comments on capital spending in relation to school buildings and maintenance. And it revealed that total capital spending on education in England was about 6.3 billion in the years 23 to 24. Now, this comprises different types of capital spending. So about 1.8 billion was devoted to school maintenance and repair. 900 million was spent on free schools. A further 900 million was spent on rebuilding further education colleges, with the remainder, approximately 2.7 billion, being spent on new schools and other aspects of capital spending. What's interesting is that the actual level of spending seemed to be about 900 million less than what had been planned. And it's likely that that reflects the significant delays that the government are experiencing in the school rebuilding programme. So what I think forecasters need to be aware of is that these delayed projects will need to come out of allocations for future spending periods. Otherwise, the plans are going to need to be scaled back. So for the current year, 24 to 25, the government plans still imply a level of spending around about 6.1 billion, which matches previous plans. However, looking forward, some slightly better news is that capital spending is set to rise to about 6.5 billion, and that was announced in the government's autumn budget of last year. From this, the government's committed about 2.1 billion for school maintenance, which is about equal to the average real-term spending over the last decade. And it's also committed 740 million to help mainstream schools adapt infrastructure to expand core provision for special education educational needs and disabilities. But that only leaves about 3.8 billion to cover school and college rebuilding projects, addressing the costs of RAC and also any other capital plans. So you can see how that figure does get watered down slightly. The report asks the question, does this represent an increase? And it concludes perhaps not. Since 2013 to 2014, overall capital spending has been around about 6 to 7 billion per year in today's prices. So the 2025-26 figure remains well within this range, and it's not significantly different from the level of spending over the past decade. However, if you think that the plans also include further education college rebuilding, it may mean that the underlying level of school capital spending is lower than over the past decade, is set to be lower than over the past decade. So perhaps, you know, the slight increase in spending isn't going to give rise to any real term difference. The big question, of course, is whether spending is meeting the current needs. The National Audit Office, in its 2023 report, revealed that the Department for Education calculated it needed approximately £5 billion per year from 2021 to 2025 in order to maintain school buildings, based on their survey of the condition of school estates. It only requested about 4 billion based on the rate that it envisaged it could actually spend the money. And in reality, the Treasury only allocated about £3 billion per year. So actual funding allocation from the government has been approximately 40% below what the government assessed the level of need to be. As I said, for 2025 to 26, school maintenance spending is due to be about 2.1 billion. So that's 13% higher than it was last year. And in real terms, it matches roughly the average over the past decade. So all this strongly suggests that school maintenance spending is well below the government assessed level of need. Obviously, what's making matters slightly worse is the need to deal with RACs. The report comments on the approach that the government's taken to addressing RAC in schools. The government's offered support through two main mechanisms: grants that have been made available for repairs and for works, and it reports that totaled 181 million in 23 to 24, and anticipates that further grants will be available in future years. But it also concludes that the costs of dealing with RAC will need to be met through the school rebuilding programme, given the scale of some of the works that are required. You'll be aware that RAC came about, or the issues concerning RAC came to the fore in 2023 when 3 roofs collapsed in UK schools, and the government, off the back of that, pledged to fund or provide funding to remove the material. But according to a recent Liberal Democrat study, 207 of the 233 schools identified to contain the dangerous material are yet to have it removed. So it is going to be something that's going to take time, and it's going to also place added pressure on school budgets. I think, in summary, it's going to come as a little surprise to many people that the level of spending on school buildings is relatively low, both in historic terms and compared with the need. And the National Audit Office and the Department for Education both recognise an increasing need to spend on school buildings. And I think the autumn budget shows that the government is choosing to top up capital spending allocations, but it's only expected to rise by 3% in real terms. And so there's probably little space or little scope for further significant increases in school maintenance spending over the next 2-year period. So in terms of what that means for schools, obviously given wider pressures on public spending, it's important now more than ever for schools to make effective decisions on prioritisation, which inevitably is going to involve deciding what works you carry out, which you choose to forego or postpone, whether you look to choose to maintain existing properties or refurbish rather than building new ones, and whether there's a potential to divert funds allocated to maintenance to other areas of capital spending. So it's a difficult position, a difficult situation, I think, for a lot of school business managers to find themselves in when it comes to balancing the budgets, because it seems like, although the government's making efforts to increase capital spending, the actual long-term impact is probably going to be fairly negligible for the foreseeable.
Thanks, Sam. It sounds very much like everything at the moment. We need more investment in our schools,
Yes.
I think is the message of the day. Thanks very much. Sharose, let's move on to something different again. So we've got a question here for you. Are service providers looking to amend the terms of a contract without notice? Can that be done?
Hi, good morning, everyone. And before I answer the question, I think I'll just touch on the few points that everyone's already mentioned. I think the key takeaway from Catherine's point is the policies and what they're going to look like. And from Sam's, the budgeting, which is very important, especially in light of NI going on the rise, NI contribution, should I say. And to answer that question, it's funny you ask, because we've had a number of queries where I feel businesses and the education sector are looking at their policies. Just to give an example, which may sound ridiculous, we had a query come in where a client was asking, we've had this email from our service provider stating with immediate effect from next month that we're going to be charging X amount, and it was a substantial increase to where they're at. Now, can that be done? That's the main question. It all really depends on what you've signed up to. We all, in our personal lives, have probably got contracts, phone contracts, internet contracts that we just don't know what we're paying every month and why it's gone up and what's going on. So I think it's important we take a step back before all these costs increase come in and actually look at our agreements. There's a number of contracts, sadly, out there which have auto renewal clauses in there, which say initially they're for a fixed period of, let's say, 12 months or 3 years. And if you don't give notice written notice in 47 days, it's a very random number in all contracts. This is going to auto renew for the initial period. To suggest if a service provider can increase their costs without any notice or amend the terms is largely down to what you've signed up to. Businesses, of course, have differing terms between them. And I think if you look at the duration of any contract, it's going to be several thousands of pounds. So my firm advice to everyone on this conference or call is to take a moment, look at your contracts, look at them ones that you feel aren't affecting you. The examples I gave, yes, they impact our personal lives, such as phone, media license agreements, internet, and any retainer that you have. And see exactly, A, when it comes up for either cancellation or renewal, and B, what period you've actually signed up for. Only when we know the answer to them questions can we look at the smaller print and advise you on what can be done and how you can look at better alternatives. I think as a matter of convenience, we sometimes put them on the back burner. And just reiterating what everyone's already said, because costs are on the rise, them little costs do quickly add up. And the same way we're all being impacted, our service providers or suppliers and everyone else are equally going to be impacted. So look at them terms. And if you're unsure, of course, we're more than happy to help and assist and navigate exactly, A, whether they're enforceable, and B, what can be done when the renewal terms are coming up to date.
Thanks, Sharose. Yeah, I mean, it's a really good point, isn't it? That our clients out there need to be looking at, are they getting good value out of the contracts they've got? And if they're not, is it time for a change? As you say, it's very easy to let those things roll on. And in times when budgets are tight and, you're looking for that spending on your estates and things, it's really important to make sure that you can navigate those contracts in the right way and make sure that you're getting value from what you're spending. So really helpful for that, thanks, Rose. And then we're going to move on to the Procurement Act with Gemma. I know from experience, I've been sat opposite Gemma a few times this week when she's been presenting on a number of webinars around the Procurement Act. So she is our procurement guru. So handing over to Gemma now on procurement.
Or in another way, is that you're saying I'm loud?
Couldn't possibly
She's
comment.
quite right though, she's quite right. I have been doing a lot on this recently because a lot of you will probably be aware that the new Procurement Act has now come into force. It came in at the end of last week. We were all waiting with bated breath for the National Procurement Policy Statement, the most latest one, because we were expecting that to answer all our questions and all our prayers with regards to the Procurement Act. And unfortunately, as has come as a result of quite a lot to do with the Procurement Act, we were let down with that. It didn't really say very much. I mean, it did outline, you know, the real heavy focus on value for money, which has always been there anyway. That's always been in the background, but it seems to be much more of a focus now. And it was about tying it into the missions of government. So it's about things like opening up the market to SMEs and VCSEs and opening up competition, making things more transparent and fair, etc., etc. Now, as part of the Procurement Act, a lot of people have gone, oh, yay, there's a bit of an exemption for schools because schools are treated slightly differently under the Procurement Act. And they are stated in Schedule 2, which means that they are exempt from certain parts of the Procurement Act. And yes, that is good news, provided you fall under the definition of a school. There is a full definition of what a school is, which I could tell you about, but I think you'll all fall asleep into your brew. So what I will do instead is say, if you want to know if you're a school, please do ask me and I shall tell you. But effectively, if you fall under that, then you are covered by these exemptions. Namely, you are basically excluded through some of the administrative tasks and requirement with regards to procurement. Because as part of the new Act, in case you didn't already know, there are 26, yes, that is 26 notices that have to be published throughout a procurement process. A lot of questions have been asked as well with regards to below threshold contracts, because particularly with schools, obviously, you can be buying things that fall under what are considered to be the thresholds in the Procurement Act. And if that's the case, effectively, a lot of people think, all right, well, we're under the threshold anyway, so the Procurement Act doesn't apply. Plus, we're exempt because we're a school, everybody's happy. And that is correct to an extent, but there are different types of contracts that it can have an impact on. And there are rules that will apply to everybody, even if it's a below threshold contract. So, for example, that riveting National Procurement Policy Statement that we were all waiting for, you are all to adhere to that. You are also as well to adhere to the idea of non-discrimination. So you must consider everybody and make it all fair, transparent, and make it clean and don't discriminate against any. And that includes bodies in the EU as well that might want to participate. And you also as well, with regards to contract modification, the contracts that relate to that still do apply to all parties. So there are some rules and regulations in there that will still apply to schools, although you do have the joy of not having all of them apply. And rather than the 26 notices, I think the only ones that you actually have to publish are 2. And it's quite unusual because I think you have to publish the contract, but you don't actually have to put a notice out saying that you've agreed the contract and you've awarded it, so you don't have to provide a contract award notice. So, you know, in some ways it is good news for schools, but you know, it's still there, it's still a thing. And if you are over the threshold, obviously the Procurement Act will kick in, but even if you are under the threshold, you still have to have it there in the back of your mind. If you need to ask any questions at all, please do let me know. That we had a question about universities and whether or not they fall under the classification of schools. And of course, as always, there's never an easy answer, but we do have those kind of answers that we can assist you with. And I think that's about as exciting as I can make it on a Thursday morning, the Procurement Act. I don't think there's anything else I can do to jazz that up for you.
Thanks, Gemma. It's always good to get the difficult procurement stuff out of the way, I feel. I'm just going to invite everybody, if you've got any questions again on anything that you've heard this morning, or if anything else has come into your mind, or if anybody's knocked on your door with a problem while we've been on air, please do feel free to pop it in the Q&A box and we'll do our best to answer or assist you this morning. I wanted to just touch on sort of one final area, I suppose, before we close this morning, which is that we have seen generally quite an uptick in the number of employment tribunal claims coming through the system. I don't know whether this is simply we've got past COVID now and all the delays and the slowdowns are starting to lift. Well, unless you live in the south, and then the employment tribunals are still a couple of years behind with some of their caseloads. But we have seen a significant increase in the number of claims coming through recently. So I just wanted to highlight really a couple of things for you in terms of what to do if you do receive notification that a tribunal claim is coming, because you do get a bit of a heads up now via the ACAS conciliation service. So anybody that wants to bring an employment tribunal claim against you has to lodge their claim with ACAS first and give an opportunity for there to be some conciliation. Now, what that means effectively in practice is that ACAS will notify you that there is a claim. They will give you a little bit of information about what that claim might look like, and they will, if there is an offer to be made, potentially put that across to you. If you get one of those ACAS notifications, please don't ignore it. Please do make sure that you seek advice on it, or you can make the call to ACAS yourself and find out what the claim is and what the individual is saying. You don't have to enter into negotiations or discussions about an offer if you don't want to. But my advice is always at least have the conversation and understand what is being said. You have then two opportunities. You can either look at whether you want to conciliate at that point, or you can refuse to conciliate. But the employee does need an ACAS certificate to go and issue a tribunal claim. So that process has to be undertaken. It normally lasts for up to 6 weeks. ACAS themselves have been fairly stretched, and there are circumstances where they're not giving that information in detail or managing to have those conversations. So it is important, if you do get the notification, to do something with it. We have seen, I think, 4 of those in the last week. So we know that some of our clients have got tribunal claims coming. What that allows you to do is to keep a lookout for it. Because very often when employees put an employment tribunal claim in, they don't direct the correspondence to a particular person, and it sometimes can be floating around in your post trays and things without anybody knowing who to direct it to. So one of the important things is, as school business managers, that you may be responsible for dealing with the mail and emails coming in. But if you have people who work within the school that are responsible for that, it probably is worth just explaining to them what those look like, and if those come in, to ensure that they get to the right person quickly. The reason for that is you only have 28 days usually to respond to these claims, and the date will be on the documentation. So it's really important that you get that to the right person quickly in order to give sufficient time to respond, particularly if it's a complex claim. And the sorts of things we're seeing at the moment tend to be discrimination claims. We're seeing more and more claims arising out of adults with ADHD and ASD, undiagnosed till later in life, which will probably fit with what you know about SEND at the moment and the significant increase we're seeing in that in children. So it's really important to be able to address those things quickly. So keep a lookout for those things. Brief the staff who are dealing with posts coming in on what to do if that sort of documentation is received, and please ensure that it gets well, hopefully to our hands fairly quickly. And I'm sure, Shirose, you probably say the same, and Nicola, the same with your claims. You know, if there is any claim documentation or anything that looks like court papers, really important to make sure people know who they need to get them to us as soon as possible. Or there are other advisors available, not quite as good as us though, I'm going to say. So on a serious note, you know, do get those to us as quickly as you can, because it's really important to have as much time available as possible. I can't see that any other questions have come in. We have got another few minutes left. Do let us know if you've got any questions arising from this morning, or anything else that you would like to ask, the floor is yours, so to speak. And we'll just give it a moment or two and see if anybody has anything else they want to ask. And I'm also going to ask our panelists if any of them have any comments or questions on what we've discussed this morning.
I think just to add to what you were saying there, Ruth, yes, getting documents to us as early as possible is very important. As unfortunately in the current climate, what we're seeing is there's a lot of opportunistic individuals as well, or companies who are issuing claims, hoping that you're just so busy, you'll miss certain deadlines, and to try and strong arm parties into settlement or mediation. And that's not what the court or the tribunal system is there for. But unfortunately, at times, a commercial decision has to be taken. And when the amounts aren't excessive, it makes more business sense to try and resolve it than instructing lawyers to make an application, to have a judgment set aside, and then resist a claim. So it's very important that all this, the administrative roles are crucial, because parties don't have an obligation to make sure that you've received in your hand the documents. They simply have to send them standard first class or other means. So yeah, it's very helpful advice, Gemma, on your part and Ruth, to say, keep an eye on the records and where they're coming in.
Thanks, Rose. And Nicola, from your point of view, incredibly important for insured cases that people are notifying their insurers as soon as these things are coming across their desk.
Absolutely, of course, Ruth. It's all a priority, because with insurers as well, it obviously can affect indemnity if you hold on to things and don't tell them and don't deal with it promptly. And as Siobhan says, the sooner we get these things, we can make sure that all the deadlines are complied with, and we're especially court deadlines, and there's no costs or financial implications in missing them.
Thanks, Nick. I think the message of the day is, if in doubt whether you should report to your insurers or get documents to your chosen advisors, I'm going to say, you know, just ask the questions. Don't worry about it. Just make sure that you ask the question. I always say no question's a silly question. It's always worth just asking if you're not sure what to do or where to go. And I know that all of the team are really adept at, if you contact one of us, even if it's not our area, we will make sure that you get to the right person quickly to be able to help you. I'm going to move towards close. I can't see that any more questions have come in. So this is your last call for any further questions that you've got this morning. Otherwise, we will look to wrap up and let you on your way. No, nothing coming through so far. We've either stunned you all into silence this morning, or we've answered every question that you might possibly have had. But either way, all of us are always available offline. If you do have something that you didn't want to discuss live on air, please do feel free to get in touch. I know our flyers and things will be coming out to you and telling you of the next education Q&A, which from memory, I think is the 27th of March.
I have no idea, so
So
with that.
we will be sending that out. Yes, that's just been confirmed to me. I am correct indeed. So we look forward to seeing you at our next Q&A. But please don't be a stranger. If you need anything in between times, we're all here to assist. But save us to say, enjoy the rest of your day. Thanks for joining us this morning, and we look forward to seeing you again soon. Bye for now.